great to see people listening from Florida, from Arcola, from Chicago and Cook, and on and on. It's thanks for tuning in, guys. Greatly appreciate that. Some of you might be, Illinois residents, just in Florida for part of the year, but regardless, there's a lot going on, and I do what I can each and every morning to unpack it for you, including with regular updates on what's going on in Illinois with the gun and magazine ban. Good morning, back at it. I'm Greg Bishop. Follow along, Bishop on Air. Twitter, Facebook, Instagram, YouTube, just search Bishop on Air everywhere, and we can connect. So Monday, we had a federal judge order the states to show each and every item that's banned in Illinois' gun magazine ban, and that's for 3 of 4 federal cases that are challenging the gun ban. Now, that's in federal courts. In state court, you've got 4 state-level cases. They all have temporary restraining orders. That's actually one from Effingham County was upheld by a 5th Circuit Court of Appeals on the issue of equal protections. And then you had White County issue a temporary restraining order. You had Macon County issue a temporary restraining order. And then you had Effingham County issue a second temporary restraining order. Attorney Thomas DeVore has 3 of these cases, and he motioned for the Illinois Supreme Court to combine those cases. Yesterday, I chatted with DeVore yesterday, and here's some of what he had to say was the rationale behind this and ultimately what this filing is.
We filed a request with the Illinois Supreme Court today for what's called a 384 motion to transfer and consolidate. It's a Supreme Court rule where if you have cases pending in more than one circuit court across the state, you can ask the Supreme Court to consolidate all of those cases into one county. They almost always will, consolidate them into whichever one of those cases would file first, which in this instance would have been the first Effingham County case. They can alter that. They don't usually do that. If you recall, they consolidated all of the Safety Act cases into Kankakee, which is where that first case was filed. So I suspect that, if they grant the order, they'll follow that same reasoning. We gave them White County as an alternative because discovery is a little bit farther along in that case. Not much, but a little bit because all of the parties have appeared in that case. So we filed that asking them to consolidate both of the Effingham County cases, the White County case, and then that Macon County case filed by State Representative Dan Calkins, all into one case.
So again, Attorney Thomas DeVore explaining what he filed Monday and the legal and kind of rationale behind the combining of the state level cases. Why do that? Why is that significant?
Well, the court has always consolidated all of these cases that we've had, these bigger issues, the mandate cases, the school district mass cases, now the Safety Act cases. When you have a common factual issue. The factual issues will be identical in this regarding the, what's in the record of this bill, et cetera. The legal issues are identical. If you recall, the one filed in Macon County by State Representative Calkins, it's almost identical, even down to the footnotes of the ones that I had filed previously in Effingham and White County. So, it's the same document. They made a little change to one of the legal theories, but it's still substantively identical to the 3 that we have filed on behalf of our clients. So when you bring them into one case, then you only have to do discovery one time. There won't be multiple sets of discovery sent out for each of those cases of which they would have to respond numerous times because the documents will be, identical. Any other depositions that we might do of the speaker or of the president would be identical. So there's an efficiency there that the court will look at. And again, I don't see any reason why they won't consolidate. They've consolidated every other, type of case in the last 3 years to this. So I think it's important. I don't think you'll get any objection from the Attorney General's office. I'm not going to speak out of turn. We've had the conversation. So, and I don't suspect you'll get any objection for anyone, to be honest with you.
So we're hearing some of the conversation I had with Attorney Thomas DeVore about him filing with the Illinois Supreme Court yesterday to combine the 4 state-level cases, all 4 of which have temporary restraining orders against the state from enforcing, but only 4 those thousands or so of people who are part of DeVore's case and Calkins's case. I think the first case DeVore had was 866 people impacted. The second case he has out of White County, 1,690. The third case he has in Effingham County, I think, has 2,000 plus, and then it's like 2,000 plus for that are part of the association in the Macon County case. So regardless, the temporary restraining order has only been for those particularly named individuals, not statewide. And I think that's what a lot of you out there have been looking for, is some kind of certainty on when this is going to be either blocked temporarily statewide, or when a permanent injunction will be issued statewide for everybody, not just for those named plaintiffs. DeVore talks about when statewide relief could possibly come.
Well, the getting to a preliminary injunction, which again would still only apply to the named plaintiffs in all four cases. That'll likely happen without a hearing, Greg, because there's, the difference between a temporary restraining order and a preliminary injunction is pretty much procedural in nature, to where you can put on testimony and present evidence at a preliminary injunction hearing, and a temporary restraining order is merely based on the documents themselves. So, my belief is that the preliminary injunction will be entered in this case without the need of a hearing. I suspect there'll be an agreed order put together sometime soon between the parties. Then that would stay in place until we get to the end of the case, and how soon we get to the end of the case, you and I can talk about in a second. But ultimately, unfortunately, there were a lot of people that got misled, unintentionally, I'll say, probably, I would hope, when Dan Calkins was telling them he was going to try to get a statewide injunction for all Ford card holders in a state court case, not in a federal case, in a state case. It's almost impossible, Greg. It's not impossible zero, but it's so close to zero. Getting a state court judge to even consider that is risky, and diminishes the chances that you get any relief at all. So that's just not going to happen anytime soon. I'm not going to ask for it because I don't think it's wise. And ultimately, Mr. Stocks in the Calkins case didn't ask for it either, because, I have no reason to believe he's not a competent lawyer. He knew that wasn't going to happen, and, his client was just speaking of something he probably shouldn't have spoke of. But that's the real answer to that, Greg.
Again, hearing from Tom DeVore, who filed yesterday with the Illinois Supreme Court to combine four cases, and I wanted to just make it clear that, we won't get to finality where the state level cases will block the law from being implemented against anybody instead of just those named in the cases that were brought forward in state court. And DeVore does provide that, again, reiterates that and clarifies it.
Till it gets to the Supreme Court, it would be. And again, in the state court cases. Now, it's possible federal jurisdiction is different than state cases. So the federal court, we could end up getting a statewide injunction out of a federal court. As you've seen, though, these federal cases don't move that fast, right? And so that could be 2-3 months down the road before that's even plausible. So, we're not speaking, you and I aren't speaking to federal issues, but as to the state court issues, the only time there's going to be an injunction that might apply statewide is when we get to the end of the case and get in front of the Supreme Court of the state of Illinois.
So I think that kind of highlights the importance of having the state-level cases and the arguments that are brought up there. The equal protections argument seems to be really what's sticking, and the ongoing case that could highlight the procedural issues that are being challenged here. Again, passing it in alleged violation of the three readings rule, alleged violation of the single subject rule, and alleged violation of the state process of due process when it comes to everybody being involved in passing legislation. Those are state level issues. The federal cases are dealing with the Second Amendment issues, the Fifth Amendment issues of not having to incriminate yourself by having to register these firearms, and then also the 14th Amendment issues, which are equal protections claims as well. So, again, that's the clear difference between the state and the federal cases, both of which are moving along, and in particular, the state cases looking to consolidate. Federal cases, you've got the state has to reply with a list of all items banned to plaintiffs who are looking for a preliminary injunction that would be statewide if the federal judge rules that. So when could we see that? Possibly sometime in April. But some final words from Attorney DeVore yesterday when I chatted with him following him filing with the Illinois Supreme Court to consolidate the state-level cases.
one thing that people ought to understand in general is that, I believe what we're going to see is a desire by the defendants to not try to, they're not going to want to answer discovery, Greg. They're not going to answer the questions that we've asked of them about how this bill was passed and, give us what you were communicating amongst yourselves with. I mean, that's all public information that the people have a right to see. We've asked for all of that if you've seen our discovery request, and they're already starting to drag their feet and to make excuses, et cetera. So, why, even though it's a technical legal issue in our case, there's a political overtone to that too. And I think the people that listen and read what you write ought to understand that there's a desire right now for all of these defendants to not want to explain themselves to the people of Illinois.
Yeah, I tell you, after dealing with these issues and all the various plays that are happening in federal and state courts, some of us are going to get a junior law degree before we know it. So kind of fascinating to keep track of this, and we will be keeping track of it each and every day here while we're live on air with Springfield's Morning News. I'm Greg Bishop, and of course, be sure to follow along, like, subscribe, follow Twitter, Facebook, YouTube. Find us anywhere. Just search Bishop on Air. All right, stay tuned. We've got tons more to